So specifically today we're going to cover topics 2 and 3 that you see here on slide 2. We're going to be talking about foreign travel after graduation and under optional practical training, OPT, the endorsement placed on the SCIS student forms. And we're going to discuss delays and procedural changes in petition processing at the U.S. Citizenship and Immigration Services, USCIS, and the delays in visa stamping at U.S. consulates affecting start dates. So we're going to start with the foreign travel after graduation and under optional practical training, the OPT endorsement that's placed on the SCIS I-20 AD student forms. You want to make sure that you have gotten the correct endorsement from the International Student Advisor or the designated school official, DSO, prior to any foreign travel after you've graduated and perhaps prior to you receiving your employment authorization document, the EAD Card. So we're going to speak about the actual changes in the policy and the procedures. As you all may note, there is a new policy that we're discussing in this presentation, and we discussed in our first part of the session the August 9, 2018 policy memorandum that is now going to be calculating the end dates differently from the past, so that it will require that students carefully review any prior stays in the United States, any possible having worked in the United States without authorization. And if you've had any overstay or work without authorization, it could definitively impact travel coming back into the U.S. after August 8 of 2018. The existing rule allows students on OPT who transfer to a different school or change educational level will have their OPT rule terminated, as well as the corresponding EAD. So that is a new change and will impact any travel back to the U.S. If you have not taken a careful, close look at any of your OPT terminations. If you are not working in the United States, even though you've been endorsed for OPT, and you travel out of the U.S., there's a whole new practice now by USCIS, as well as U.S. Customs and Border Protection, USCBP, the officials who do the inspections at airports or ports of entry, even if you're driving from from Canada or from Mexico. Those agencies are going to be looking at the databases, and if the ICE agency, the U.S. Customs and Immigration Enforcement Agency, have changed or annotated the SEVP, the SCIS, the Student Exchange Visitors Program database, which is responsible for the notations for any study programs, duration of student programs, duration of any J training programs, or in the M visa classification if you're in a vocational program. That database has all annotations of start dates of programs, end dates of programs, any annotations having to do with graduation or transfer from one program to another or from one school to another. So that database has to be clean as possible, so that when you do travel into the U.S. And any annotations therein that show that you may have fallen out of a student program or not or have traveled without getting a work letter or an offer letter, as we'll talk about shortly. Any of those annotations in that program that are incorrect could lead to not getting back into the country, being denied entry into the country, having an F1 visa canceled. And so what this new policy that went into effect in August of 2018 has stated is that the USCIS and or the USCBP will, and ICE also, will be reviewing them, and ICE specifically would be the ones notifying any student to take corrective action if applicable. That's why it's critically important to make sure that all of your contact information in the SEVIS program is up to date and current and correct, so that if there is any corrective action that must be taken, and the USCIS is going to be advising you or notifying you, they have the correct contact information so that you can take action without negatively impacting any possible transfer to a new school. Reinstatement applications could be impacted, and or travel back into the U.S. Is not going to be impacted. Please note that if the OPT is terminated and your EAD is terminated on your SEVIS, you should not at all work with any terminated EAD application that could subject you to the possible 3 or 10-year bar that we also covered in our first session, where I discussed at length and in detail the August 9 policy memorandum. I would ask you to review that session if you have not heard it in a few days, or you have not heard it at all. It's best to start this particular presentation with that first session and then move into the second and lastly the third. Also note that if you continue to work in the U.S. with a terminated employment authorization document for periods that could expose you to the 3 or 10-year bar, you could face removal, in that if ICE does note in the SEVIS database or in any applications for any immigration benefit that there could possibly have been some work without authorization, you could subject yourself to removal, meaning you could conceivably be issued a notice to appear, an NTA, at an immigration court because of the working without authorization for periods that would expose you to the 3 or 10-year bar, or even working without authorization that do not expose you to the 3 or 10-year bar, and you are working without authorization. That's a violation of your F1 student status, J or M status, and therefore you are subject to removal from the U.S. Let me also state that the government wants to propose, or is actually in the mode to issue a proposal sometime in the near future, which would end the duration of status, the D/S annotation or endorsement issued on I-94 records for students, J's or M's, that come into the United States. And they are proposing, or they are going to be proposing, that instead of a duration of status endorsement, the students entering the U.S. under those visas would receive a specific date of expiration on their I-94 record, and not the DS. They want to, the government, especially this administration, want to be able to have a cleaner, clearer method of calculating overstays in the United States for the students here, or trainees. Therefore, they wish to propose that rather than getting DS, you would get a specific end date, and the end date in all likelihood would be the end date of the student program, or the if it's a 4-year program, you would get the end date on the I-94 to be matching the expected or anticipated date of graduation. So it's going to be a rule that would impact all of the student body, as well as universities, and of course any prospective employers that now need to be aware of the end date of a study program and the beginning date of a particular visa work visa classification may also be impacted by this proposed new policy. So please be always checking the USCIS, the ICE, and even the SEVP websites for any of the proposed policy memorandums or proposals that are going to impact your stay in the United States. In this presentation, I also wanted to just touch upon the issue of travel on the OPT EAD card, the card that is issued subsequent to you having graduated from a full course of study. And the EAD, as you know, is the Employment Authorization Document card. Typically, when you received the endorsement on your SEVIS form, the I-20AD, and you had a valid F1 student visa, you were able to, and even with the EAD card, you were able to travel back into the United States just simply with that endorsement and no real need to show evidence of employment. Now the practice is that U.S. Customs and Border Protection, USCBP, will be scrutinizing at the border when you are traveling back to the U.S. from an overseas trip post-graduation with an OPT EAD and the endorsed I-20AD form, SEVIS form. You will need to be able to show that you are actually either employed in your area of discipline or that there is a prospective start date of employment. It cannot be just simply an invitation for an interview or an offer letter without a finite start date. And also, I recommend, and you'll see the tip at the bottom of this screen on the slide, that you should be carrying a signed offer letter, a offer letter where there is a signature by the employer and an acceptance by you, the student, future employee, to work under the OPT EAD. Truly important to carry some evidence of that employment. Should you have a paycheck, that would be also evidence of the working in the United States, and not just simply you're seeking employment under the OPT endorsement. So this is a new practice, one that you need to be aware of. Be careful when traveling. Don't forget to carry these documents. Keep either JPEG photos in your smartphone. The ideal best evidence, of course, is always the hard copies that you should carry in your back pocket on the way into the U.S. Again, here I touched upon it earlier in another slide, but I do want people to be aware that there is a proposal to replace duration of status. Every year the administrations publish a fall regulatory agenda, and in the fall 2018 regulatory agenda of October 17, they included an item that they wish to have, that ICE, wishes to replace DS admission with a maximum period of authorized stay, and that would, of course, impact the end date depending on the visa classification. M visas are usually of 2-year duration, F1s typically 4-year duration, J1, depending on the classification, can be as little as 6 months to as long as a 3-year or even 5-year end date. So the administration through ICE wants to have date certain admissions, so it reduces all sorts of confusion. It controls or minimizes overstays, and again improves the integrity of the F, J, and M visas. All of these are goals under the current administration. The anticipated proposed rule publication date is sometime in September of 2019, with a comment period to follow. The reason the administration published it so early in 2018 is to get institutions, educational institutions, academia, students, non-for-profit organizations, the types of employers that typically would have either F or M or J, one foreign national students, trainees in their work population, is to get them ready so that nobody is caught off guard in September of 2019, probably with the rule going into effect in 2020. You have an approximate 12-month period of preparation, understanding, allowing everyone to get programs in place, have websites ready with these proposed changes, and just to get students ready for the fact that they are now going to be responsible for checking their I-94 end date upon entry once this rule goes into effect. And if extensions have to take place, then they will have that, they're ready to do so. Come to the third topic that this presentation covers, which is all of the delays and procedural changes in both any petition processing at the USCIS, and then subsequently all the delays that we are facing in the visa stamping process at U.S. consulates, which then of course affects start dates of any study programs or of any employment programs that require folks to go overseas and apply for either business or pleasure or study programs overseas that would then require them to apply for visa stamps to get back into the country. There are considerable delays right now at these overseas offices, and so it's important to keep that in mind when planning any kind of employment in the U.S. Since January of 2017 to now, almost 23 months after the new administration went into office, we have seen a considerable breakdown in a variety of different agencies, processes, and processing and reviewing of applications by the various consulates overseas. A number of factors have impacted the reasons why there are increased delays. We have, of course, the increased vetting requirement included in the administration's executive orders that the U.S. consulate review applicants more carefully than they have in the past and vet these applications far greater than they were being reviewed in the past. And so what that means is we've seen an increase in the way the consulates have selected certain applications for administrative processing. That's the process by which the U.S. consulates require that the Department of State's main offices in Washington, D.C. review applications before the consulate can take action and approve and issue the visa stamp into a passport. Some of these delays can go as long as 12 weeks from when the person applies for the visas. So while we do not have any formal statistics on the nationalities that are being selected for greater processing, or for the administrative processing, it does appear that in certain cases, if an individual is from certain Asian countries, and the individual is actually working in certain industries, there is increased usage of the administrative processing feature at the consulates. So if, for example, there is an individual from India working on chemical processes, or is a chemist working at a chemical engineering role or the chemical company. Those cases seem to be selected far more often than not for administrative processing. So it's critical to note the possibility, to be prepared for that possibility, to have a contingency plan in place if an individual goes overseas to apply for a visa after graduation or needs a new F1 visa for another study program, just to be aware of the fact that they may be overseas for longer periods than anticipated. Also, if you're working subsequent to graduation under the OPT EAD notations and endorsements, and you go home for the holidays, and you note that you may need a new F1 visa stamp in the passport, be aware that you may be outside for longer than you anticipated, and that the company should be made aware of that possibility and have you perhaps work remotely from the country where you are applying for that visa until that visa stamp is actually issued. Also, it's important to note now that effective on October 1, 2018, there was a new USCIS policy memorandum that stated that the USCIS will have enhanced abilities to actually, after a denial of a change of status from F1 to H1B, or from one H1B to another H1B, if the applications are denied, certain types of applications are now being sent, are having USCI issue a notice to appear so that the individual would eventually receive a date to appear at an immigration court. And the policy memorandum was to impact all types of USCIS petitions and applications. The USCIS quickly realized that they would have to stagger the implementation of this policy memorandum to allow sufficient administration work done on files before the NTAs were issued, and thus they have started to only implement it on certain applications. Right now they're working on the policy is fully operational under any applications for the I-539 to change or extend the status, as well as the adjustment of status applications. Those are those applications that are done at the end of an employment-based or family-based processing where an individual is seeking to adjust from a non-immigrant status, an F1 status, let's say, to that of a resident. And those applications are already starting to see the issuance of NTAs when they have been denied by the USCIS. The policy has not yet been applied and and implemented for any work visa petitions, I-129, H-1B petitions, let's say. We anticipate that will occur in the first or second quarter of 2019, as the USCIS is equipped both with staff and a budget to be able to implement the issuance of the NTAs in petitions which are denied and the individual has no other status in the United States and therefore would be subject to removal. The USCIS is, however, of course, advising applicants on the I-539s and adjustment applications, as they will the beneficiaries of petitions like an H-1B petition. There is language on the denial that alerts the applicants of the possibility of being placed in removal and receiving a notice to appear. They are giving a date certain by when the individual must depart the United States, and if no date certain is on the denial, they are giving a time period by when the individual should depart the United States unless the applicant is appealing the decision of the denial, and by which the USCIS will not issue the NTA and will wait for the whole appellate process to be completed before the file is then pulled once again for an NTA to be issued. So there are certain events that would prevent the USCIS from issuing an NTA, but they are limited in scope. It is critical, if anyone receives such a denial, to immediately seek legal advice of a competent immigration attorney and not wait till the last minute. If there is a 30-day period to appeal, then it is critical to seek that advice at the front end of those 30 days and not wait till the last minute. Very important to read those notices very carefully, those decisions very carefully, so that the corrective action is taken quickly and you're prevented from having an NTA issued. Other matters that you should be aware of very carefully now is this F1 cap gap status and work authorization extension that has been issued in the past and was issued this year in 2018. The cap gap used to protect students right through until the date of a decision on an H-1B petition, and you could continue to work until the visa H-1B petition was decided. If approved, you could continue to work without issue, and the cap gap would protect you from any unauthorized presence in the United States or unlawful presence or unauthorized work in the United States. This year, this administration issued a memorandum on 9/11. Prior to that, sometime in early September 2018, that stated that the work authorization was only valid through September 30th, 2018, and any work thereafter would be considered to be work without authorization. You would not accrue unlawful presence, but you would be subject to having worked without authorization should you continue to work after 9/30/2018 and before a decision was made on any pending H-1B. So very important to make sure that I know we're in December 2018, so that if you did continue to work from October, November, and now early part of December, that's only roughly 60 to 70 days of work without authorization. You should immediately stop working so that you're not impacted with having any unauthorized employment. That is, if your H-1B is still pending and no decision's been made. If you have that H-1B approved and you're working based on a change of status, you're completely fine and would not be subject to having worked without any authorization. Unless, of course, your work authorization was only, your H-1B was approved at some time in November of 2018, but you continued to work from October 1 until the date of the H-1B. That period of time needs to be noted in any future immigration applications, any benefits that you're seeking. It will not render you inadmissible or removable, nor will it impact any green card application if you did have some time of work with the expired period of time. So again, note any dates of work between October 1, 2018 through November or December, whenever the H-1B was decided. Another policy memo that has really changed the landscape of legal immigration, business immigration applications is the one that went into effect on September 11, 2018, where the USCIS was given the discretion to deny any I-129 H-1B, any immigration application or petition, family or employment or asylum or any type of application for a U.S. immigration benefit, they can deny them without issuing a request for further evidence, an RFE. And that is going to be very important for anyone seeking an immigration benefit, whether it be family or business, work visa, a green card, to really make sure that the application petition is prepared completely, fully, review it, re-review it, double check it, have a second, third set of eyes to look over the application before it is sent to the Immigration Service, because after 9/11 of 2018, the USCIS will, in all likelihood, issue denials if they, in their discretion, review the application submission and note that there are deficiencies, but rather than issue an RFE, they will just deny the application. Does not mean that the USCIS will not issue RFEs. It just simply means that they now can just go right to the denial without giving you an opportunity to respond accordingly should there be any deficiency. The USCIS, in all likelihood, would issue a request for further evidence where there may be some missing photos or evidence like that. We suspect will still, the applicant will still have an opportunity to send in those photos. But if you're missing a birth certificate and it's a legal requirement, then they will issue an RFE. Very important to always review very carefully the instructions for any application you are submitting to the Immigration Services. Look on the USCIS website under the form number. There is a link to the actual instructions of the forms, and read those instructions carefully. Ensure that you have all the documents listed under that page in the instructions. Do not go by the checklists that the USCIS has very cleverly added to their website, but is not all-inclusive. It is somewhat vague under certain classifications, so do not follow those checklists. It is very strongly recommended that you look more at the instruction sheet of the forms rather than the checklist that the Immigration Service has put up on that website. We come now to the portion of questions and answers, and I've listed 6 different questions here that I believe would be critical for you all to keep in mind. Obviously, these are not all inclusive. If there are any questions or issues that you want clarified, please always refer to my contact information on my slide at the end of this presentation and the other presentations, the other 2 sessions, and you can reach out to me and I'd be happy to answer or clarify any confusion on what I've presented or any questions that you have as a follow-up. So I'm going to cover these 6 separately and I'll answer them as I go along. Can I travel back to the U.S. after graduation with just an interview invitation and my EAD card that is under OPT? And my answer, as I said earlier, is no. It is advisable to have an actual offer, signed offer, meaning the employer has signed it and there's been an acceptance and you have signed it. Pay stubs, any evidence that you're actually working under that OPT is recommended. Otherwise, you could face difficulties in getting into the U.S. And may even be turned away if you're not able to show that. Number 2, can I travel back to the U.S. after graduation in between jobs? And the answer to that is you can have evidence of your having worked at Company A and evidence of an accepted offer, a signed offer letter for the new job, that and of course a valid passport, valid F1 and EAD card. that should be fine, and you should be able to get back into the country. But if you only have interview options for the second job, then I would recommend against coming back into the U.S. until you actually have secured a signed offer letter. Number 3, why is DS used, and why are they proposing to change it? Okay, so DS, duration of status, is a practical means by which to annotate an individual's entry into the United States for a program that may have a change in end date. Individuals sometimes change programs. The programs have different end dates, and so the duration of status endorsement is a far more practical way of keeping tabs on how long an individual can stay in the United States. And the reason they're proposing to change it is because it actually leads to a lot of confusion on the part of the students, employers that are seeking to have them work after graduation. They want to have a greater control of those coming into the U.S. and have and just ensure the integrity of these study programs are kept by the foreign students, and not just prolonging programs under this duration of status. Number 4, why is there increased vetting when applying for F1, M1, or J1 visas? Variety of reasons. Primarily, the administration wants to have a greater control over individuals who come and go into the U.S. and do not have a finite period of time to remain in the United States. They perceive to see quite a bit of fraud and misuse of the student programs, noting that there was a study made of how many overstays in the United States, and the majority of overstays are typically Fs, Ms, or J visas, and thus this is one of the classifications that the administration would like to have greater control over, and ensure that there's compliance with the programs, ensure the integrity of study programs, and so this is why there is now the newer policy memos that we have seen impacting students in the U.S. They want, of course, the U.S. Department of State through the consulates to assure in their interviewing of these applicants that they are coming to actually study for a finite period of time in the United States. Number 5, what if I receive a denial of an I-539 application to change status and depart the U.S., but an NTA is issued? Okay, so in those instances, it is recommended that you seek legal advice from an immigration attorney before you attempt to re-enter the United States, and have the NTA either closed at an immigration court, removed, withdrawn, if you can, of course, prove that you departed the United States timely. So that is a really an event where an NTA is issued that must be addressed before you attempt to re-enter the United States. Even as a tourist, if you were to come in either with a formal B visa stamp or under the visa waiver program, under the ESTA program, but there is an NTA that's been issued against you, you truly must take care of that, have that addressed, closed completely before you attempt to re-enter the United States. Because if you attempt to re-enter and an NTA is issued, they will deny you entry, cancel your visa in all likelihood, and then you've got 2 different critical matters to take care of before you could return to the United States on any visa classification. Number 6, how long is it taking to receive H-1B petition decisions after 10/1/2018, the date I must stop working in the U.S. under F1 cap gap? The answer to that is, unfortunately, it's not very well known how much more you have to wait. In some cases, the decisions were made a few days after 10/1/2018, and in other cases, there are still pending H-1Bs from this past H-1B cap season. So it is probably best to take a look at the processing dates of the H-1B petition under the service center where the H-1B petition was lodged, to see if you're outside the processing times based on the USCIS website's online status page. And if so, there is a way to complete an inquiry form for matters that are outside the processing times, and you need to monitor it almost weekly, asking the particular service center the status of the matter, so that a decision is sort of forced from the USCIS through a bit of a nagging process. But really it's uncertain as to how much longer they're taking. Always check the status page for the service center where the H-1B is pending to see what date they're working on and your receipt date. That concludes these question and answers, but of course if there are any more, please feel free to contact me, and I'd be happy to answer through email or a phone call. So this is the page where I listed a number of different resources that you can go to on a regular basis, and I encourage everyone to do so. These are the actual official government sites for each of the agencies that are responsible for governing immigration in the United States, and of course there's also the U.S. Department of State outside of the U.S. that governs the consular offices processing of non-immigrant visas, including the FJ and M visas. I have included on the bottom one private organization, the Association of International Educators. It's a national association. That association is very well written and organized, and it'll give you up-to-date analysis on any of the policy memorandums or the procedural changes, that any of the agencies issue. So I encourage you to visit that website. And then, of course, the most practical resource always is your international student advisors or your international student officers at your university, particular school, your institution. They should be equipped to be able to answer questions regarding these changes and to give you advice. And most importantly, they're the ones that are responsible for maintaining your SEVIS record to make sure that it is correct and complete, and very importantly, that your student record is closed upon graduation. And I know that there's a 60-day grace period for students to stay in the country, and there's a 30-day grace period for J visas. So schools will not close those records until those grace periods have come to an end. But you now need to stay on top of them to ensure that those records as students are closed. And again, if you're here in the U.S. under an EAD from an OPT endorsement, then you want to calculate the 60 days from the expiration date of that particular card, assuming that you're still in the country and are working in the United States with that document. So you want to have a close relationship with them, maintain I don't know if a friendship, but a relationship, so that you can call upon them at the appropriate times to ensure that records are clean and that they're closed when necessary. So those are just some of the resources that I lay out for you. Of course, I'd be happy to answer any questions, and I can be counted as a resource should you need me to be there for any questions. Lastly, on this last page here, we have a glossary of all of the terms that we use throughout the presentation, all three sessions, in fact. So we've spelled it out in each of the presentations at the end of each presentation. So you'll note that in the world of immigration, we work with a lot of acronyms, a lot of visas. So they're all spelled out here, so it's easier for you should you not recall what I am referring to when I use an acronym. This is an easy little glossary. Lastly, of course, is my contact information, and please, by all means, call or email me with any questions you may have.